local government autonomy, it's really not strange to us here in Nasarawa State. And the reason being that His Excellency Engineer Abdullahi Esule, being the governor who has played for the observance of the rule of law, who is the governor whose interest it is to see that development has reached the grassroots ab initio. And that is the reason why, since his assumption of office in 2019 till date, His Excellency Engineer Abdullahi Esule has never, ever tampered with a dime that is credited to the local governments in Nasarawa State. It is a point of note that Nasarawa State has 13 local governments, and we are one state that is a state that is governed by someone who has a very wonderful background, that fairness and justice are his watchwords. And so local government autonomy is not strange to us because, one, when he came on board, he has conducted a series of local government. This is about the third one, local government election His Excellency Engineer Abdullahi Esule is conducting. And during the pendency of the case instituted by the Office of the Attorney General of the Federation, apparently that case has nothing to do with Nasarawa State because, one, we have an elected officials at the grassroots level. We equally have no issues with tampering with the funds of the local government. And three, there has never been any situation where the local government tenure has been truncated abruptly without following the due process of the law. And so these are the crux of the issues that were before the Supreme Court. And apparently we were actually not affected. So what we are going to say is that the judgment just came timely, and that's at the time that the tenure of the local government, the existing local government structure was still in place.
All right. Thank you very much, Labaran Magaji, the Attorney General and Commissioner for Justice, Nasarawa State. I'd like to stay with you. We have reports that joint accounts, with local government councils has been abolished in Nasarawa. Tell us, why did the state government go ahead to do that? And we hear that implementation of the funds, disbursement of funds, local government is supposed to begin, in November, and the state governor already went ahead to abolish joint accounts. Why did the governor take that decision?
Well, like I told you, His Excellency the Governor has been a proactive person, and recall that the judgment of the Supreme Court was delivered on the 11th day of July 2024, which entirely abolished, quote unquote, the practice of the joint account between the states and the local government areas in the states, and held that local government council is entitled to a direct payment from the federation account of the amount standing to its credit in the federation account. Judgment, whatever it is a judgment. And like I said, His Excellency the Governor is a person that can be characterized by the adherent to the law. And it came, like I said, the tenure of the pending local government, the existing local government structures was almost coming to an end. And election was already fixed for the 2nd of November, and they needed to take an oath under a new law. And so the need for the Nasarawa State government, under the leadership of my governor, to amend the existing local government law to conform with the judgment of the Supreme Court becomes very, very imminent. And the repeal of the Nasarawa State Local Government Law 2018 becomes imperative, so as to align the state local government law with the judgment of the Supreme Court, as aforementioned. And to this end, there are some features which includes For example, Section 30, subsection 6, 7, and 8 of the 2018 local government law, which deals with the appointments of interim management committee of the local government council level, was repealed because the Supreme Court frowned at any structure other than democratically elected structure. So the existing law, that is the 2018 law, local government law, has this provision, making provision for what we call interim management committee. So that section was repealed. Now, Section 43 of the 2018 law, which also deals with the state's joint account, was equally repealed because this is the wordings of the Supreme Court. So consequently, we in Nasarawa State now decided that the practice of the state joint account under the 2018 law is no longer obtainable under the 2024 law. And this, in consonance to this, the practice of the deductions from source of 5% under Section 63 of our law of the local government council and the development areas monthly statutory allocations is to be remitted, and that is usually remitted to the traditional council of each local government council, has equally been abolished. So in place of this, we had a provision under Section 6.1 of the law 2024, which provides that each local government and area administrative council, because the nomenclature of the development areas has been tampered with by the new law. So what we have today is area administrative council, respectively. So in the same vein, Section 60, subsection 4 of the 2024 law made a new innovation by making allocations funds into which all remittance and disbursements shall be made directly to the Emirates Traditional Council. So the Traditional Council can now be on their own, and recall that even in the new law, specific roles were created for the Traditional Council, considering their importance and relevance in the scheme of things. So it is equally pertinent to equally note that while we have development areas in the 2018 law, the new nomenclature of the areas in the current law is now Area Administrative Council, and this is contained under our new Section 65. So these and many other innovations, as we can continue to discuss, have made features, in our new laws, which is really the vision of His Excellency Engineer Abdullahi A. Sule.
Thank you very much.